na many the honorable Ernest and Nogbe any and Komo were minority and this Mrashe ni edema the Ashaiman constituency na many no any and Komo. Honorable, if you can hear me, good morning. Thank you for your time.
Good morning, my brother. Good morning to all your listeners.
Now, a promise to say no pay. Very well.
One him say me too and yet
honorable, you managing in kakra na ye de brofo nso afrafa na etiefo etime atiase. Now, first off, Andra, minority stage a walked out during the passage of the E-levy bill. Concerns are more raising. Say one, it wasn't part of the business of the day. Andra at the time I'm more sitting. No, two, other papers so enya dia a bar so and then muntimin consider. Three, you make the claim, sir. Some of you know report a finance committee no a year concerning the passage of the E-levy bill no and Ramon Famodi no ama it was far more a surprise to more minority bench no so say majority no at the by the more reason why I move free and Rashe Begum Sanet here.
It's just one side of the story. That is not the main reason why we moved out.
Okay, so help us know and help us understand.
We have been surprised. We were even surprised actually because we have been waiting for this E-levy to be on the business statement for a very long time, but they were not bringing it. Knowing very well what they wanted to do, they were not putting it on the business statement. Also, they don't bring it on the other paper, as we all know. So it was a surprise to us that they were bringing it yesterday, or they brought it yesterday. Now, the report was late since last year. The report was late since last year, 2021. And so, if they will be bringing, you will be bringing a report. You will be taking the report as of yesterday. It is just a normal that you give all of us a new report. Or if it is the same report, we are all aware, so that we could compare whether the report that was late last year would be the same report that will be taken yesterday, which they did not do. We raised alarm. The speaker directed that the report should be given to all members, and it was done. Now, we debated it. The surprise element is most critical to us because as of yesterday, one of our colleagues, frankly speaking, was in the Supreme Court. That is Ashaiman was in the Supreme Court.
Okay.
So we were 137. We were 136 as at yesterday. Now, they were 137. According to reports, they were 137. And when we counted to really, because one of our colleagues, who was also ill, very sick, was brought in an ambulance. We are not that insensitive. A colleague who was ill, could not speak, could not do anything, was brought in an ambulance to come and cast vote because of E-levy. We are not that insensitive that they should remove our colleague from an ambulance, brought him to the chamber to cast his vote, and then whisked away. Now, if that is the case, they were left with Honorable Adjoasafo. Did not turn up to Parliament, or for a very long time has not been coming to Parliament. So invariably, they are also 137. Now we are 137, but lesson with one colleague who was in the Supreme Court. So we became 136. Do not forget that the Supreme Court says you cannot take decision when you are less than one half of members of Parliament present and voting. And so Supreme Court decided that one half of the 275 will be 138. Now, if you are 137, you cannot take decision. Granted that our colleague who was sick was even in the chamber. Once he was not there as at the time, you are 137. You cannot take decision. So we decided to work out, to give it that illegitimacy, to be able to take that decision on the E-levy, so that it can give us enough time to read the report and also make our input, because they are clause by clauses. If for nothing at all the report is taken, There are clause by clauses. There are amendments that we have to prefer to that effect. And so that is the reason. So if you realize that one of our colleagues was in the Supreme Court, then we are 136, and so they are 137. We would have given them the legitimacy to form a quorum to take decision.
Yeah, but let's stay on that same subject. Now, is it about the issue of vote casting that you have a challenge with, or it is the issue of forming a quorum for the commencement of business? Because we are told that 1/3 of the total numbers that we do have in Parliament will form a quorum for business to begin, of which you require about 92 of members of Parliament to be present. Now, you require 2/3 of the total numbers we have in Parliament to be present to be able to cast their vote for a decision to be made. And so, which one precisely do you have an issue with?
We are talking of decision.
Decision.
We are not talking of starting business at all.
Okay. Okay. So the impression is that your member of Parliament for Asin North was at the Supreme Court yesterday, as at the time of sitting, and so he could not take part or be part of voting. For which reason the majority equally did not have Ajua Safo in the House, and so they equally were falling short of one member of Parliament, bringing their numbers to 137. And likewise, your members coming down to 136.
Exactly so.
And so your claim is that the majority cannot take a decision with 137 members.
If we are not there.
If you are not there.
Exactly.
I see. But we are equally told that at the time where the question was put by the speaker, some members of your bench or your side were still in the chamber.
It still doesn't add up to anything. You see, in 2009, Honorable Doajaho ruled. Because there was an issue, and you see the minority leader at that time, which is Honorable Chairman Sabonso, stood on his feet and made it clear that their side will not be part of that decision. And so they are walking out. When they walked out, Honorable Opari Ansah remained on his seat. Do you understand? Honorable Opari Ansah, who was their member, remained on his seat. And Honorable Do Ajaho said, your leader said you are walking out. The fact that you are seated in the chair, you have no voice in this matter.
That story is attributed to the STS deal, right?
Very good.
Okay.
So you have no voice to this matter. And so the moment your leader gets up on his feet to say that my side will not be part of this, it has covered everybody, whether the person was seated in the chair or was moving out or whatever, and the question was put. It is neither here nor there. So
yes,
we
let
me ask you this question.
Okay.
Just hold on. Let me ask you. There were 3 stages as at yesterday.
Okay.
The first stage was to adopt the report. You understand? And that was what we worked out on. Granted, without admitting that, yes, some of our colleagues were still in the chamber when the question was put. And so that has given it legitimacy. What about the other 2 stages? That is the stage of clause by clause, recommendation and the amendment, etc. Where there are also major decisions to be taken. What about the 3rd reading, which is the final reading to pass the bill into law, where we in the chamber? That is also another point. And so you can say that, fine, we have granted you. Take it that we were in the chamber when it was passed. What about the 2nd stage, the clause by clause? Were we there? What about the 3rd reading? Were we there when the question was put on the 3rd reading? Were we there to adopt the bill into law?
Respectfully, let me take your indulgence on this. Respectfully, the committee's report, the finance committee's report on the transfer of electronic levy bill. Now, the first reading, we are told, was done on the 16th of December 2021, and then according to the report, the bill is accepted to go through a state of urgency, and so after the chairman equally casted a vote at the committee level, it is assumed that the bill must go through a situation of an agency, and so there is no way we can say or argue out that within a day there was no way members of parliament could have taken the bill through the processes, therefore passing the bill at the end.
I'm not arguing over a certificate of agency or not. I'm talking of decision. Decision at a particular time of taking decision. It can be taken it can be taken even within 30 minutes. We do that even in Parliament. But within all these 30 minutes or whatever it is, you must have the quorum to take that decision, that major decision. Within all the 30 minutes, all the levels, you must have the quorum to take those major decisions. If there are 4 major decisions that you have to take within 30 minutes, 3 hours, 2 hours, you must have the quorum, because at any point in time, a member can rise on his feet and point to the speaker that we do not have a quorum. You can have quorum within 5 minutes. The next 10 minutes, you don't have that quorum, and the member can raise it.
Okay.
That point.
Yes, I do understand you. That point is well made. But the question again is that by what methodology of vote casting did members of parliament use? If it is by the popular voice voting, and then you still had some members from your side in the chamber at the time the vote was called, then automatically you cannot classify those that were voting against the bill as opposed to those that were voting in favor of the bill. So your members could equally be counted as part of the people that approved the bill.
So, no, my members, if really it is true that some of our members were there,
yes,
at that particular stage, I told you that yesterday, they went through 3 stages. They went through 3 stages to pass the bill into law. I think the first stage was when they are alleging that our colleagues, some of our colleagues were still in the chamber. So granted that even they were really in the chamber. But I've explained to you the ruling of Do Ajaho earlier. But granted that they were in the chamber, what about the other 2,
the 2 stages?
2 stages. Were they there? They were not there. Because, after the time, they were walking out. These people were walking out before they claimed the question was put. Not that they were seated on their chair. They were on their chair. Not that they were seated. They were moving out. So they could not get out because of the nature of the door. So they were all rushing to go out. They could not go out before the question was put. And you say you are counting them. Granted, you did that. What about the amendment stage, clause by clause stage? What about the 3rd reading, which is the major one, the 3rd reading to pass the bill into law? That is the major aspect of lawmaking. What about that one? Were they there as well? It's all that I'm arguing about.
But help us understand, do we have to go through all these processes in terms of procedure before the final vote is being put, or the question is being put for voting by the speaker?
Yes, that is our standing orders. That is what the Constitution also says. It must go through all these things. If you read even Article 108, Article 106 or thereabout, you see it, of the 1992 Constitution. So the procedure is, a parliament is governed by rules and procedures.
Yes, I do understand, and I do agree with you. But my question is that if a bill is going through a certificate of urgency, does it necessarily have to go through all the processes before the final question for voting is being put to members of parliament?
Yes, otherwise we would have been doing a rubber stamping. It has to go through all the processes. Otherwise, anybody can just say the bill is under certificate. You see, the bill being under certificate of agency is not different from the normal bill. Just that you have to work assiduously and extensively on the matter on a particular day to take it. But all the other processes that would have happened in a normal bill coming to Parliament and taking it through the other, all you have to do all those processes, but just at a limited time. Within a limited period, you must exhaust it. Otherwise, you will not be doing a good job. That is all. That is only the difference. The time is the only difference, but the process and procedures are the same.
So the impression created is that with the other stages for which the bill had to go through, minority did not take part of those processes.
Exactly.
Okay.
Exactly.
And so you cannot consider yourself to be part of the processes that came or saw the passage of the bill.
Not at all. We were not part of it. We were not part of it. And that can be tested in any competent court jurisdiction because we were not part. Clause by clause, we were not part. Yes, we even debated the bill before we walk out. Clause by clause, we were not part. Third reading, that is the major aspect, we were not part. And so you did not have the quorum to have the third reading of a major bill like this. A bill of national interest, you do not have the quorum to pass it. The 138, they don't have it.
Now, we are learning of a lawsuit that has been filed at the Supreme Court against the passage of the E-levy bill. Now, what reliefs do you seek the Supreme Court?
Oh, that aspect, I think the lawyers will do that. The lawyers will do that. But from our conversation, you can deduce from what we are seeking the court to do. It's a nullity. You understand? What they did yesterday was an illegality. And so we can only ask for the court to nullify it.
But will you be happy if the Supreme Court is to grant you that sort of relief? Because then again, the minority make us understand that Parliament, you are masters of your own game. And so once something is done in Parliament, you don't expect the judiciary to step in. Why are you now running back to the Supreme Court?
You know, the ruling of the Supreme Court is binding. You know that, whether you disagree with it or not.
Yes, I know it binding, but yet still you disagreed with the Supreme Court ruling.
And so you think we shouldn't go back to the Supreme Court even though we disagree with the ruling?
Yes, I'm just asking a simple question: that are you now not inviting the Supreme Court into the activities of Parliament?
Was Supreme Court invited into the activities of Parliament earlier? If that is the case, then that has become the norm, because the ruling of the Supreme Court is now law that is binding on members of Parliament and Parliament. And so, therefore, if they have taken the step to do it first, then it has become norm. Now we are no longer masters of our own rule. If the Supreme Court can strike out our standing orders, Order 109, and tell us to do A, B, C, D, we are no longer masters of our own rules. They have started it and will continue on that tangent. It is not a matter of we are inviting them. They have been invited, or they invited themselves into our affairs already, and so we have to follow suit because their decision has become rules and their decision has become law, which everybody must obey. So we are not inviting them. They were invited and they have also invited themselves. We will just submit ourselves to them once again.
And does the minority now believe in the Supreme Court and its judgment? Do you believe in that?
The fact that we did not believe in the judgment, which we still do not believe, does not preclude us from going to them. And this is a test case. That will be a test case for the Supreme Court. What is good for the goose must be good for the gander. And so we have come. This is your ruling. The same thing has happened. So judge it. Yes, so it's a test case. We'll see how they go about it. That's all.
I think posterity will be the best judge with this particular situation. Thank you very much.
That is why even when we go to the Supreme Court and they say, oh, the bill was validly passed, we will not fight over it, we will not do anything, but we want to expose something. Let us go to the Supreme Court. At the end of the day, we'll come back to have conversation on it.
Thank you very much for your time. I'm grateful.
Most grateful, my brother.
Okay. To the Honorable Ernest Henry Nogbe, Menino Eddie and Komono Ashaiman MP on the ticket of the National Democratic Congress. Bringing us to 44 minutes after 8 a.m. This is Kessben 92.9, 93.3 in Kumasi and across the country. More live on Kessben TV. On our social media handles, Kessben TV on Facebook, on YouTube, and Kessben FM 92.9. Maybe